Good afternoon. Welcome once again to this 5PB webinar. I'm very pleased this afternoon to introduce to you two talks. The first for the first two-thirds of the hour by Edward Jenkins, Queen's Counsel, and Ben Douglas-Jones, Queen's Counsel. And then for the final 20 minutes or so, a talk by Miriam Smith on the Victim Right to Review scheme. But we will start off by turning to Ed Jenkins QC, who together with Ben will be talking about the offence of fraudulent trading. Ed.
Good afternoon. The purpose of my talk this afternoon is to deal with the realities of this offence in the context of the pleasant life we have at the moment. For many directors of very successful companies, there is a maxim which is never waste a good crisis to do which you otherwise couldn't do without having a major strike or something like that. And they use it to restructure in a way which gets them into a very strong financial position. And they use the delightful smokescreen of saying, we have to do this because we're in such trouble. But for others, to trade and continue to survive, the only way they can really do it to save what is in fact a sick company of theirs is to trade fraudulently. Now, slide 2. The first thing a business should always want to know is whether the company is sick, and they should do that by asking the question in the slide. If the answer is no, then the company should cease trading unless it has alternative sources of finance, such as bank loans, shareholder equity, or something like that. If it continues to just trade despite that, then the directors run the risk of being prosecuted and being locked up for a maximum of 10 years. And let me assure you that even Ford Open Prison is a great deal worse than anything any of you are going through at the moment. And therefore, this has to be the main question any businessman should be asking, as even Richard Branson needs help following the collapse of his revenue for his airline, let alone restaurant owners or indeed high street solicitors, because everyone's revenue stream except for Waitrose, Sainsbury's, Tesco's has effectively dried up. So slide 3, please, and we move into this. What are the elements of fraudulent trading? It's set out the actual provision on the slide, and it applies not only to directors, and this is particularly important, but to anyone who has a controlling or managing function and who takes some positive steps in carrying on the business. It must then be carried on dishonestly, with intent to defraud its creditors or for any fraudulent purpose. The latter will catch any fraud on customers or counterparties who are not technically creditors of the company. It will be sufficient if a potential defendant intended to put at risk the economic interest of any potential victim, and that is by, for instance, trading when there was no real prospect of the company being able to pay its debts. It would, as such, have an intent to defraud, as defined in the well-known case of Wellham. This means in this day and age, a director will be guilty of this offence if it is proved that he, A, either never intended that the company would pay its debts, or B, that when the company incurred the debts, he knew that he had no good reason for believing that the company would have the money to pay the debts when they became due or shortly thereafter. And that is important. Always remember the shortly thereafterwards. Slide 4. This looks at what little help there has been in some respects from the government. The provision of loans, furlough pay, and that's coming to an end, and potential deferral, and I underline only deferral, of HMRC liabilities. But they are matters which a company can take into account when deciding whether it will be able to pay its debts. It has been said that it will suspend the wrongful trading provisions in section 214 and 246ZB of the Insolvency Act, and that was to be retrospective, as you can see. I have been unable to find any trace of that legislation being introduced so far. In essence, those provisions as such would enable a court on the application of the liquidator or administrator to make a director of a company which has gone into insolvent liquidation or administration personally liable if he knew or ought to have known there was no reasonable prospect of the company avoiding going into liquidation or administration. Such a suspension was welcomed by business, but query whether it's actually going to come into effect and query whether it will make any difference. But other areas, in particular, there has been suspension of Section 2 of the Competition Act, and it's temporary, but it's been for groceries, the dairy supply chain, health services, and the Solent ferries. And that's to allow them to cope with the virus problems by, in particular, sharing stock levels, facilities, workforces. But there is to be no sharing of costs or pricing information. The Competition and Markets Authority, the CMA, has said that other businesses may be able to take advantage of the Section 9 exemption, but the CMA guidance is explicit, and it is this, that it shouldn't be interpreted as applying to any other matter than those relating strictly to or arising out of our current situation. They won't tolerate businesses using crisis as a cover, and equally, it must be concerned solely with consumer need and protection as to be at the forefront of these measures. They have set out guidance concerning what they feel might qualify under Section 9 exemption, and it's to avoid a shortage or ensure security of supply, ensure a fair distribution of scarce products, continue essential services, or provide new services such as food delivery to vulnerable customers. And as such, if they do that, they are unlikely to be problematic from a competition criteria, but they cannot go any further than is reasonably necessary. And the CMA have made it plain that they will pursue those whose conduct is not necessary to respond to the pandemic. Well, you may say, well, don't think the CMA will never do anything. But so far, the CMA task force for the virus has written to over 187 firms, accounting for over 2,500 complaints about large price rises alone for such things as personal hygiene products and food. There is a delightful term for that activity. It's called price gouging, and perhaps puts it in its proper context. Further, the CMA has also taken upon itself to issue guidance about the aspect of fraudulent trading where it has a concern. And it says a business should not seek payments for a service it knows it will be unable to provide. Where the business reasonably expects to provide the service as agreed, the CMA's view is that in general the business can require customers to carry on making those payments for the time being. That could be the case, for example, for some services due to be provided later in the year. Consumers' rights to refunds will depend on whether the services can be provided when the time comes. But as lockdown continues, in whatever form it is on Monday, it is anticipated it will be difficult for regulators and businesses alike to anticipate when such reasonable expectation to provide services or pay refunds to customers will dissipate, and when lawful trading will become unlawful. Now, slide 5. Despite the government saying they're trying to assist by suspending, this lists what is still going on. And you will note the civil liability for fraudulent trading, which is personal liability for any person carrying on a business with intent to defraud the creditors. In section 423, transactions at an undervalue. The Companies Act, the fiduciary duty of directors is still there. And as indeed is section 2 of the Competition Act, unless you come within the exemption. I now move on to slide 6, please. Criminal liability. Well, obviously fraudulent trading is still there, and its individual alternative under section 9 of the Fraud Act, which is for individual trader liability. Section 188 of the Enterprise Act, which I'm sure you're all aware is the cartel offence, which deals with price fixing and criminalises all aspects of the competition law. And in terms of trying to survive in this climate, that is clearly going to be a difficult problem for people to be aware of. And as such, anyone who's contemplating cooperating with competitors on distribution will be well advised to take advice, and in particular consult with the CMA and at least do everything openly, and that is often the best way to start to prepare any defence to a cartel allegation. Slide 7. What should directors do to avoid prosecution? 1. Document all decisions to show that they were reasonable in the light of the circumstances. Constantly updated management accounts will be crucial supporting evidence of honest director decisions. Such accounts can be prepared on the going concern basis, and that is very important for to meet any allegation of fraudulent trading, as opposed to a far-sale valuation, which is sometimes used by overzealous prosecutors who've looked at a company after its collapse, valued the assets then, far sale value far lower, and they thought, well, we've got an overwhelming case, but you then come along and say that was wholly unreasonable, look at it from a going concern basis, and the case is easy to defend. But that said, consider whether, but for this present crisis, the company would be able to continue to trade on the basis of the going concern test. If the company was going under in any event, then it has to stop trading and can't hide behind the virus. Ensure you've taken all steps to reduce the cost of business and avoid paying bonuses and dividends in particular. Ensure that creditors, where possible, are kept fully informed. Take advice, as I set out there in detail, and in particular as to the actual meaning in law of government announcements. None of them amount to a license for an unviable company to trade. But even if the company is viable in the short term, that will be no defence to not make necessary adjustments for the future. And in a sense, you could say that is what British Airways and the other airlines are doing by announcing these large redundancies, because they're mindful short term they may get over it, but long term they will be in difficulty unless they make these adjustments. So finally, what is the position? And that's slide 8. And that's where I say simply caution at this stage, and you'll see why, for good reason. The government is providing substantial funds, and the UK is fortunate that it can do so at this stage. But even if the suspension of section 214 comes in, it will be of comparatively little importance, as you can see. And perhaps you might say it's more akin to saying you won't be prosecuted for having no driving licence, but you can still be prosecuted for dangerous driving. And one final word of caution. Directors must remember the Health and Safety at Work Act when they come to opening up again. Because if you fail to take precautions to protect your workforce and leave them, you could as such leave yourself open in a worst case scenario if your new workforce coming back in all catches the disease and some die, could leave you open for a manslaughter allegation. But that is for another webinar. And now for the serious analysis of the law, over to Ben.
When Opus set out the lyrics to the one power ballad hit wonder, Life is Life, they must have thought, this isn't really fit for purpose, but it'll do. They then added 2.5 chords, and almost 40 years later, they're still touring. When Bob Dylan wrote, people don't live or die, people just float, he undoubtedly thought, float rhymes with coat, that'll do. 30 years on, several people have written theses about what it means to float. Now watch this segue. When in 1928, parliamentary draftsmen decided that they wanted to go home early on a Friday afternoon and added the words, open quotes, for or for any fraudulent purpose to the offence of fraudulent trading, they didn't know that 90 years later, the requirement for the company to be in the throes of being wound up would have been removed, and the words for any fraudulent purpose would effectively create, in the context of otherwise tightly codified fraud law, the possibility of judges giving a jury a route to verdict that reads, members of the jury, you need to ask yourselves, 1, are you sure this smells bad? 2, are you sure the defendant was dishonest? Add into the equation Ivey and Genting, as confirmed last week in the case of Barton and Booth, in the context of Hayes, where for dishonesty, industry practice and ethos are not relevant measures of the objective standards of ordinary decent people in the context of dishonesty, there is a danger that you have the most widely drawn nebulous offence imaginable. In recent years, fraudulent trading has begun to become a gateway to potential injustice, I suggest, open to abuse by overzealous prosecutors and difficult to defend because of the number of obstacles presented if you are defending a trader. We've seen in consumer fraud how fraudulent trading is increasingly being used as a sort of consumer protection from unfair trading regulations plus offence. Easier to prove, none of the technicalities of CPUTs, higher penalties, no time bar, and without the need to comply with the Rivington and Goldstein Attorney General's guideline requirement that applies to conspiracy to defraud. In more general white-collar crime, it's creeping in as a device, I suggest, to avoid the hurdle of justifying charging common law conspiracy. At the moment, I have a case pending leave to appeal against conviction in the Court of Appeal Criminal Division, where in a business-to-business sale, the identity of the buyer was misleading, but the judge ruled in the context of fraudulent trading, first of all, deception was not a necessary component of, open quotes, for any fraudulent purpose, close quotes, the second limb of fraudulent trading, notwithstanding the reliance on a misleading act. Secondly, there was no risk of injury or prejudice to a proprietary right as a necessary component of the offence. And thirdly, the judge found that no intention to act fraudulently was necessary. In the many years which will accompany COVID-19 and post-COVID economic recovery, I suggest fraudulent trading will be the natural focus of any charging decision where the business of a company is carried on in a way which cuts corners in such a way as to prejudice people's rights and interests. There is an onus on us as practitioners in fraud, I suggest, to keep it within its appropriate bounds, or the route to verdict ends up being, as I've suggested, it looks a bit dodgy. Is there dishonesty? If so, guilty. And the uncertainty and danger that businesses faced, as described by Ed a moment ago in the context of COVID, is perhaps exacerbated when one considers two cases to start with, if I may. First of all, Grantham 1984 case. In that case, it was held that a jury may consider it dishonest for debts to be incurred when they could at best be repaid months late. And in Lockwood in 1986, it was held that a single dishonest transaction carried out with intent to defraud a creditor could constitute carrying on business with intent to defraud creditors in the context of fraudulent trading. We're all aware of the criticisms of conspiracy to defraud. The offence is too wide, it's insufficiently clear, and it's argued that it breaches the basic tenet of the law that it must be sufficiently clear to allow a citizen to be able to know how to live within it. Despite the major fraud reforms of 2006, fraudulent trading is arguably open to being abused like conspiracy to defraud, specifically because of the potential abuse that can attach to the second limb of the offence, that the offence is made out if business is carried on for any fraudulent purpose. In 1928, and you'll see why I'm going back there in a moment, fraudulent trading was an offence confined to the carrying on of a business in the course of a winding up. It created both an offence and civil personal responsibility for directors for the debts and liabilities of the company. That state of affairs was carried through into the 1948 statute. Then came the 1985 Companies Act, and the offence under the 1985 Act was under section 458. Civil liability was then hived off into section 214 of the Insolvency Act 1986. Now, section 458 of the 85 Act widened fraudulent trading to apply irrespective of whether or not the company was being wound up, and that has in turn been carried through to section 993 of the 2006 Act. So it created an offence where company business was carried on limb 1, A, with intent to defraud company creditors, or B, with intent to defraud creditors of any other person, or limb 2, for any fraudulent purpose, in both cases being the director being knowingly a party to the carrying on of business in that manner. But in the case of limb 2, you'll see from the wording of the statute there, with no statutory requirement of intent to defraud in relation to that limb. There's been a gradual widening of the offence as to the width of the offence under section 993 of the Companies Act and section 9, the individual offence under the Fraud Act, which includes a similar wording in relation to the second limb, although it includes the word other, so for other fraudulent purpose. Mike O'Brien, Queen's Counsel, Member of Parliament, Solicitor General at the time, arguably gamekeeper turned poacher, said in 2006, when the Fraud Act offence of fraudulent trading, so section 9, was being debated, fraudulent trading is an activity offence and carries procedural and evidential advantages because it's not limited to specific fraudulent transactions. Focusing on the word advantages, you may think that the advantage was not that of the defendant seeking to invoke his Article 6 rights. The explanatory notes to section 9 of the Fraud Act state fraudulent trading is in effect a general fraud offence comparable to conspiracy to defraud, but requiring the use of a company instead of the element of conspiracy. I'm going to touch on 3 cases. Inman, 1967, in that case, Mr. Justice Marshall held that the offence could be split into 2 limbs as it dealt with 2 different types of offence: fraudulent trading with intent and fraudulent trading for the purpose of achieving certain things. Limb 1 offence is necessarily included as an essential element intent to defraud a specific class of person, As to the breadth of that class, I'll touch on the case of Kemp in a moment. With Lim 2, fraudulent purpose, there has been little judicial gloss to help define its scope. Without gloss, the natural interpretation would allow for an extremely broad, general dishonesty offence, wider even, I suggest, than conspiracy to defraud, as it relies entirely on the concept of dishonesty. At least dishonesty is an essential element of fraudulent purpose. In Patrick and Lyon Limited, which was a 1933 case, and you may raise an eyebrow about me going back to 1933, but you'll see why now. Mr. Justice Morm held that the words defraud and fraudulent purpose, where they appear in the section in question, are words which connote actual dishonesty. According to current notions of fair trading among commercial men, real moral blame. He went on to say, no judge, I think, has ever been willing to define fraud, and I'm attempting no definition. I'm merely stating what, in my opinion, must be one of the elements of the word as used in this section. And that expression, according to the notions of fair trading among commercial men, no real moral blame, is something which has featured recently in cases where judges are directing juries, and you may think that it approximates to a second form of dishonesty. So you end up with a form of dishonesty followed by a form of dishonesty being your route to verdict, with no clear direction being given. In the 1982 case of Cox, Lord Justice Tasker Watkins, while dealing with Lim 1, said in the context of intent to defraud that that limb contained an ingredient of dishonesty, but he also said without dishonesty no jury could convict a defendant of fraudulent trading. In other words, obiter, he was saying you need dishonesty for limb 2 as well. Well, that's something perhaps. The thing about fraudulent trading in those days was that it was assumed that it only applied in the context of a company trading insolvently. Then came Kemp. In Kemp, the appellant, through 2 limited companies, induced other businesses to believe that they'd ordered from his company and had to accept, when they hadn't ordered it, carbon paper, which for the Generation Zs among us was a consumable in bygone decades. The appellant was charged under the 48 Act with Lim 2, fraudulent purpose, fraudulent trading, where the fraudulent purpose was said to be the obtaining of property by deception. On appeal, the appellant argued fraudulent purpose should apply to creditors only, as it was an alternative to Lim 1, intent to defraud creditors, and should be interpreted eustem generis. Therefore, as the allegation did not concern creditors, there was no fraudulent purpose, so the conviction shouldn't stand. Well, the Court of Appeal blew that notion out of the water and held that the mischief the Act was aimed at was fraudulent trading and not simply fraudulent trading vis-a-vis creditors. So it was sufficient, they said, if the person defrauded was a potential creditor of the company as opposed to an actual creditor. That included the company's customers. So Kemp extended the offence so that where a person is knowingly party to the carrying on of a company's business, guilt is established upon proof that that business was carried on for any fraudulent brackets, dishonest brackets purpose. Arledge on fraud notably says that there is a serious objection to the Kemp construction, as it makes fraudulent trading just as vague as conspiracy to defraud, I suggest even vaguer, without even the requirement of conspiracy. It virtually amounts to saying, says Arledge, that the offence is committed if a business is carried on in a way which a jury consider to be dishonest in some respect. The Kemp construction begs the question, what is the purpose of Lim 1? It really does leave judges with the scope of directing the jury if the act was dishonest, guilty. So on the basis of that interpretation, you don't need deception, you don't need intent, You don't need any interference with a proprietary right. I'll come back to that in a moment. Insofar as criticism of the offence is concerned, between 2002 and 2004, the Law Commission and the OFT considered the offence. The Home Office's consultation on fraud in 2004 cited there, that is the Law Commission and OFT's respective positions, and recognised the width of fraudulent trading. What might be needed, they said, is a new provision in addition to Companies Act fraudulent trading applying to non-corporate traders offering the same evidential advantages, brackets, advantages again to the prosecutor, brackets. The Home Office recognised that such a provision may be desirable to deal with continuing scams, but it wasn't a simple issue, and the term fraudulent purpose may not be clear enough. Considering to whom the offence should apply, the Home Office recorded that it could be argued if conspiracy to defraud is to be abolished on the ground that it's too close to being a general dishonesty offence, it's illogical to extend this very wide Companies Act offence, that is fraudulent trading, outside the corporate sector. It was also said that it could be argued that fraudulent trading should be confined to the corporate sector on the ground that liability to this very wide offence is part of the price that companies pay for the benefits of their limited liability. The Home Office also recorded in 2002 that only 34 people were sentenced for the offence. So at the time, it wasn't particularly significant because it wasn't being used to any great extent. The Home Office consultation followed what I suggest was clear criticism from the Law Commission on the use of general offences of dishonesty. In its report on fraud reform, it concluded that dishonesty should be a negative element in any crime of fraud, so that where other elements of the crime can be proved, a lack of dishonesty will be a defence. However, the Law Commission did not consider it right that dishonesty should be the key positive element in a fraud offence, i.e. it should be a necessary element of the offence, but it should not be sufficient of itself. The Law Commission also noted, even 4 years before the Fraud Act, that other financial and corporate offences respected regulatory codes, and the distinction between those regulatory financial offences and more general mainstream criminal offences would be, to use their word, obliterated by a general dishonesty offence. A general dishonesty offence, they said, would widen every dishonesty offence dramatically and indiscriminately, and that would be wrong. Nevertheless, the Law Commission did not recommend the narrowing of the offence, and it expressly recommended the only extension of the scope of the offence should be to non-corporate activity, and fraudulent purpose should not be redefined. In Arledge on Fraud, the editors suggest that it's arguable that conspiracy to defraud doesn't comply with the minimum standard of legal certainty required by the ECHR, and if that were tested successfully, the Human Rights Act 1988 would require a court to adopt an alternative construction which didn't define the scope of the offence entirely in terms of dishonesty. When considering what you may need as a minimum, I suggest to avoid breaching Article 7 of the ECHR, namely that no one shall be found guilty of a criminal offence which was not an offence before the act or omission. Last week's 5-judge judgment in Barton and Booth, 2020 WCA Crim 575, is perhaps instructive, gives an idea as to what might be appropriate. There, the elements of conspiracy to defraud were held to be properly described in the indictment when they were defined by reference to deliberately exploiting the appellant's position to control or obtain money or proprietary rights of others for the benefit of the appellants or their companies. Not only was there that particularisation in the indictment, but also the indictment was accompanied by 6 voluntary particulars. So there was infinitely more definition in that indictment than in several I've seen recently in the context of fraudulent trading, where I have even seen as particulars of fraudulent trading elements of CPUT offences thrown in for some sort of good measure. What did Parliament intend? Well, legislators haven't interfered with Limb 2. It can't have been Parliament's intention for this limb to serve as a general fraud offence, even broader than conspiracy to defraud, I suggest. In 1987, the Law Commission, in a working paper on conspiracy to defraud, said it may be that by analogy with cases of conspiracy to defraud, fraudulent trading under this limb is trading with intent to injure by dishonesty some proprietary right of another. In Evans, which was endorsed in Barton last week, Mr. Justice Hickinbottom, as he then was, and then Lord Justice Fulford, now Vice President, accepted our submissions that with conspiracy to defraud, you need a risk of injury to a proprietary interest in a non-deception case. So, what do I suggest should be the elements of Limb 2, fraudulent purpose, fraudulent trading, as a minimum? Well, it needn't necessarily involve financial loss. It may cover the type of case at present caught by conspiracy to defraud, for example, a person performing public duties where the fraudulent purpose is to deceive a public official to grant an export license to a company when it's not entitled to one. So with Limb 1, thinking COVID, Limb 1 will be made out, if you look at the slide on the screen, when a defendant, 1, puts the trader's existing creditors at risk of not being paid, 2, causes people who aren't his existing creditors to become his creditors at a time when he is or is likely to become insolvent, or 3, he does things which give rise to causes of action sounding in damages against him in favour of people who are not his existing creditors. And Limb 2, so come back to what been discussing, the fraudulent purpose would be, and this is really for debate rather than a definitive view, it's a working view if you like, knowingly carrying on business dishonestly, A, with intent to defraud a non-creditor by deception. There's no need there for him or her to be defrauded so as to cause loss. B, the public duty limb, so with intent to defraud another by deceiving him or her into acting contrary to a public duty as opposed to a mere power. Or C, deliberately putting another person's property or financial interests in jeopardy. When fraudulent trading comes into the spotlight in this corona and post-corona era, as I suggest it will, I suggest we need to do what we can to keep it within its proper acceptable bounds, or injustice will be done. To end as I started, with a gratuitous reference to music of a certain era, Ron Cornelius described playing guitar for Leonard Cohen in the 1960s and 1970s. They took a form of LSD or PCP called Desert Dust 23 nights straight. On the 23rd night, he went to play an F-sharp minor chord and fell flat on his face on stage. My suggestion is, by not guarding against the expansion and abuse of Limb 2 of fraudulent trading, there will come a point where a prosecution will end up falling flat on its face.
And we've got 2 questions before we go, which are both going to be for Ben to answer. The first for Ben is this: what is the scope of the proprietary right or financial interest that is to be put at risk under Ben's suggested Limb 2 of the revised, as he proposes, fraudulent trading offence? Ben?
I think the short answer is something of value or something tangible. The need for the creation of a risk to a proprietary interest stems from recently Viscount Dillon's opinion in Scott, and before that from Lord Radcliffe's speech in Welham, which referred to a pecuniary or economic interest. There has been debate as to whether it's necessary. Evans is recent authority for the fact that it is, and Miss Justice Higginbottom's, as was analysis, is, I suggest, the tour de force. It was suggested in Hayes it might not be correct. Then in Barton it was suggested that it was correct, albeit obiter. In Hayes it was suggested there was no reason to confine a proprietary right to a beneficial or equitable interest, or the kind of interest needed to launch a claim for equitable tracing. So I think it's up for grabs as to how extensive it should be, but strictly speaking, it should perhaps be confined to something of valuable or tangible.
Thank you very much. And the second question is this. Would the mens rea requirement of the offence be satisfied by blind eye knowledge?
There's an acknowledgement in Bank of England and Morris that blind eye knowledge would suffice for fraudulent trading. It was on the basis of a concession before the court in that case, in the Court of Appeal Civil Division, but they held that knowledge would include blind eye knowledge, namely a firmly grounded suspicion of specific facts and a deliberate decision to avoid confirming that they exist. So I think that's the answer to that.
Thank you. And we now have a question for Miriam as well, which is this. The question is, the scheme, as you've mentioned, is for victims only. Would it be possible for a complainant animal protection group to challenge a decision not to prosecute an allegation relating to an offence against an animal? And would they still have the right to have a fair opportunity to make representations?
I think the short answer is no, largely because of the, I don't know if my camera is on, because of the definition of a victim within the guidance, which makes clear that the victim includes close relatives of a person whose death was directly caused by criminal conduct, parents or guardians where the main victim is a child or youth under 18, police officers who are the victims of crime, a family spokesperson of victims with a disability or who are so badly injured that they can't communicate, and businesses, provided they give a named point of contact. And it makes clear that if someone wants to submit a request for review on behalf of a victim and doesn't fall within one of those definitions, they need to have written confirmation that they have authority to act on behalf of the victim. So it would seem that a group, some sort of rights group here for animals, wouldn't fall within that definition. It's not like judicial review, for example, where you can have interveners in decisions to provide representations of a general nature that aren't specific to the case at hand, in a way that, for example, in a judicial review might seek to assist the court with matters of general principle or arguments that they may wish to hear.
Thank you, Miriam. And Ben, I think you want to come in on that question as well.
There was a case concerning anti-Semitism in which there was a straightforward judicial review of a CPS decision not to prosecute, and the point was not taken in that case that there might have been an avenue under the VRR scheme. So I think that's as high as one can put it.
Thank you very much. Well, thank you everyone for joining us. We'll be back next Thursday at 3 o'clock when Miranda Moore QC will be talking about headlines in allegations of baby shaking, and Kath Fennell will be talking about Section 41 of the Youth Justice and Criminal Evidence Act. Until then, I hope you have a very nice bank holiday weekend. Please, as always, stay safe, and we'll see you next week. Okay, we're done.